Let's get a legal perspective on some of our big stories today. Former President Zuma's application for stay of prosecution and the setting aside of public protector. Advocate Busisiwe Mkhwebane's report into the Estina Dairy Farm. I'm joined by Tobani Myandu, who's the director at M&S Attorneys. Thanks so much for your time on SABC News. In court today, we saw Advocate Mkhwebane talking about the amount of time that this prosecution in this matter has taken and saying that's one of the reasons it should be setting aside. Is that a strong legal argument?
Nzinga, good evening to you as well as the viewers at home. Certainly, the points that Advocate Sikhakhane SC sought to make in that regard are one of the considerations that one has when such an application is brought. This application is founded in terms of the Constitution under Section 35. Section 35 of the Constitution generally says and provides that every person, accused person that is, has the right to have their trial run in a manner and in a time that is good or in good order. So there cannot be unreasonable delays. So in the instance of a delay, it is certainly one of the reasons why a court would consider that the application be successful.
Another issue that was raised was that Bulelani Ngcuka at the time should have charged former President Jacob Zuma with Schabir Shaik. That didn't happen.
Certainly. Again, one of the points that Advocate Sikhakhane for the former president sought to make was the fact that what we've got to consider is where we come from as a country. We come from a period where people could just cast aspersions on others on the basis of their race, on the basis of their political affiliations and the like. He was therefore making the point that what they will try and do in argument is to demonstrate that just because a person that of the name of Jacob Zuma comes before a court of law should not be treated differently and afforded lesser rights than would ordinarily accrue to a person who was accused in the general sense.
There was an issue around language in the court and what Advocate Sikhakhane could and could not do, which languages he could speak. I think he said he was told that he could speak in Zulu and last minute he was told he couldn't. What's the issue there and what's the issue around language in South African courts?
The issue, as we understand it, was that initially he Advocate Sikhakhane, had made the point that he'd like to do his opening address in a language of isiZulu, which is his first language, also the first language of the accused. We understand that initially the request was granted, but just before the matter could begin, and in chambers, the judges then said this is not going to be allowed. Now, you ask a secondary question that says, what is the legal position insofar as languages are concerned? Firstly, I must say that the official languages of the country are all recognized and can be used in a court of law. However, we know that during the year 2017, the Chief Justice, arising from a meeting that was held with the fellow head of courts, came out with a decision that said English shall be the official language that is used in a court of law. He specifically said in that ruling or that decision that this doesn't mean that parties may not use their native or other languages that they seek to use. The most important consideration that must be made, however, is whether or not a court sitting, so if you take, for instance, a court that sits with 3 judges, one being a first language speaker of English, the other being a first language speaker of isiXhosa, and the other being one that speaks isiZulu. They should all be communicated with in a manner that is going to facilitate the advancement of the matter going forward.
Let's go to the other issue that we've been dealing with, the setting aside of the Public Protector's report in Pretoria today, saying it was unconstitutional and invalid. What happens next?
Well, what happens next is that the Public Protector has the right that is enjoyed in law by a party who's dissatisfied with a court's decision to take it to a higher court for a ruling in the opposite. I must say that from a legal perspective, the citizens of the country should at this point be very happy. I say this mainly for this reason. We should appreciate the fact that the Office of the Public Protector is an office under the umbrella of Chapter 9 institutions in the Constitution. Now, the Chapter 9 institutions in our country in terms of the Constitution are meant to be the watchdogs over public servants in general, the executive authority, the president. Now, in instances where the Chapter 9 institutions do not get things correctly, the courts should come in, intervene, and provide proper direction. And of course, one may ask, as you did earlier, where do we move from here? Well, if the court has come to a wrong finding, it's open to the Public Protector to take the matter to a higher court for a decision in her favor.
Tobani Myandu, the director at M&S Attorneys, thanks so much for your time.